All rise. Ladies and gentlemen, the Supreme Court of Alabama, hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
We welcome a full house here today for a case that involves an institution that affects most Alabamians. And because of that, it even affects the justices on the court. And we've had recusals so that there would not be a conflict of interest. And we have two special judges appointed to join us. We have Chris McCoo from the Court of Criminal Appeals and Christy Edwards from the Court of Civil Appeals. And they will be acting as special justices on this case. So, with that said, Madam Clerk, would you call the docket, please?
In case number SC 2023-0385, ex parte, the Alabama West Florida Conference of the United Methodist Church, Incorporated, and General Counsel on Finance and Administration of the United Methodist Church. Arguing on the behalf of the petitioners, the Honorable Bob Northcutt and the Honorable Alan Livingston. Arguing on behalf of the respondent, the Honorable Ryan French.
Well, Mr. Northcutt, you may begin.
Mr. Chief Justice, Your Honors, may it please the Court. Again, Bob Northcutt for the petitioners. Harvest Church United Methodist was a member church of the United Methodist Church for over 25 years. Therefore, it was subject to the United Methodist Church Book of Discipline that's been in effect since 1797. The trust clause has been a part of the Book of Discipline that entire period of time. Through this lawsuit, Harvest Church United Methodist wants to unilaterally sever its relationship with the United Methodist Church and with the denomination, take its church property, and act contrary to the Book of Discipline. We believe that is precluded by this court's decision in the AME Zion versus Zion Hill decision. The Harvest lawsuit seeks a judicial declaration that would require that the Alabama West Florida Conference and the denomination have no interest whatsoever in the church property of Harvest, trust clause or otherwise. They also seek an injunction that would preclude the conference and the denomination from enforcing not only its rights, but its obligations under the Book of Discipline. Obligations that they would owe to other members of the United Methodist Church and to this conference. The remedy sought in this case, injunctive relief, we believe, would be contrary to the First Amendment, the church autonomy doctrine, and the Oklahoma Supreme Court has recently agreed with that position in Timmons 1 and 2, the decisions we made the court aware about in the fall. We also believe it would be an unconstitutional interference with matters of church governance and doctrine. And we cite for that proposition the U.S. Supreme Court cases of the Kedroff and Kresick versus St. Nicholas Cathedral decisions, the Serbian Orthodox case, and Our Lady of Guadalupe that are cited in our briefs. Harvest admits it wants to have a court declare as unenforceable perhaps the most fundamental, important, and longest-standing tenets in the United Methodist Church, which is the trust clause. However, we would respectfully submit that to grant the relief sought by Harvest in this case, the court would have to consider and possibly also declare unenforceable multiple additional provisions of the Book of Discipline. And we would respectfully submit that in order to do that, that would be a judicial rewriting of the Book of Discipline.
Let me interrupt you there just for a second. The Haney's Chapel case is a case that we've decided, and it was a Methodist church case, a UMC case as well, correct?
Correct.
And in that case, we decided that we could, in fact, consider the questions there dealing with property, even though the Book of Discipline applied. So why isn't that a spotted horse case?
Your Honor, we would suggest for multiple reasons. First of all, Haney's Chapel was decided in 1998. It was a plurality decision. It was prior to the enactment of paragraph 2553, which is the disaffiliation provision that comes into play in this case. It was decided purely under state law, and in that case, the court had before it two deeds. One deed was to the community for a union church, which the court held was so woefully inadequate in the description of the grantee as to be void. The other deed...
But that's a merits issue, right? We're here in the jurisdiction issue.
That's right, Your Honor, but I'm talking about the difference in the churches and the difference in the decisions and why we believe there is a jurisdictional issue. At least in that case, there was some premise to rely on neutral principles that did not get involved in ecclesiastical issues.
What about this case is ecclesiastical? I mean, why we're talking about a property issue? What makes that ecclesiastical?
Good question, Your Honor, and thank you. For several reasons. First of all, ecclesiastical means more than just matters of faith. It also takes into consideration anything and everything having to do with the church, which would include church governance, which would include church doctrine. So in this case, in order to settle the property dispute, the court would have to declare as unenforceable, at a very minimum, paragraph 2501 of the Book of Discipline, paragraph 2503.6 of the Discipline, but also because this relates to a disaffiliation that is being attempted by Harvest, that also takes into play consideration of paragraph 2553 of the Discipline.
This affiliation is not the issue that's in front of the court. It's just a property issue. Am I not correct?
Your Honor, we would respectfully suggest that it is before the court in this sense. Harvest has made a point of the disaffiliation in the complaint. They wish to disaffiliate, so even if paragraph 2501 were declared unenforceable, if Harvest Church wants to leave with its property, it still has to comply with paragraph 2553, because at all times relevant to this lawsuit, in order to disaffiliate, there was only one path, and that was to follow the requirements of paragraph 2553, which they have not done. And there are other requirements other than the church property. So it brings up this issue. Had Harvest just simply wanted to leave and take its church property, they could have done what 250 other churches have done in the conference, signed the disaffiliation agreement, complied with paragraph 2553, and left with the property. But they refused to do so. So until they comply with 2553, even if 2501 was declared to be unenforceable...
Had they said they wouldn't comply with 2553?
Yes, they have. Okay. That was in an email that's in the record in this court, Your Honor.
But if I'm not mistaken, now you correct me if I'm wrong, the deed that applies to this church did not have the paragraph 2503. Am I not correct? 0.6, I think is what it was.
Sure. So the underlying deed in this case was the grantee were three individuals who were trustees of Harvest Church United Methodist. That gets to be a distinction again with Haney's Chapel, because there was no reference in the Haney's Chapel case or in some of the other cases relied upon Harvest in this case. But in this case, the deed referred to Harvest Church United Methodist Church. The Articles of Incorporation did, the Certificate of Incorporation did, multiple other documents did, and the Certificate of Organization that was given to Harvest Church in 1997 refers to Harvest Church as a member of the United Methodist Church and subject to the United Methodist Church Book of Discipline.
Mr. Northcutt, I don't think you answered my question. The deed in this case did not have any reference to the paragraph 2503.6, correct?
It did not, Your Honor. And so we would cite the court's attention to the AME Zion case and also the Carnes v. Smith case, a decision of the Georgia Supreme Court that I hope to speak to in just a moment, where it was held that notwithstanding the fact, both of these cases held the same. One from the Georgia Supreme Court, one from the Supreme Court in this case. Both held the same. In those cases, there was no underlying deed that mentioned the United Methodist Church or had a trust clause. In both of those cases, they noted, however, that because the local church was a member of the United Methodist Church, a hierarchical denomination, participated in its activities, received benefits from the church from doing so, that the property would be subject to the trust clause in the Book of Discipline, even if it was not in the underlying deed. And that's what paragraph 2503.6 in the United Methodist Church Book of Discipline specifically provides.
So, Mr. Northcutt, let me just ask this. So with the deed here, I got kind of a who has title and who has the ability to convey title to this particular parcel listed in the deed?
Your Honor, the property would be owned by Harvest Church subject to the trust clause of the United Methodist Church.
But if the trust clause is not mentioned in the deed,
pardon me?
If a trust clause is not mentioned in the deed, kind of like a right of reverter, if somebody's going to buy the property, you did a title search, would that necessarily come up and you would be unable to convey marketable title?
Your Honor, I'm getting a little bit out of the record here, but that issue has come up, and the consent of the conference has been requested in that very specific circumstance because of the right retained by the United Methodist Church. And this is not just unique to the United Methodist Church. This is true in other denominations as well.
But I guess my point is if it's not in the deed, and there's a separation between ecclesiastical law and I'm going to suggest real property law, and if we look at the deed, which is what courts do routinely, whether it's a church or a corporation or individuals, and we don't see that in the deed, why can't whoever is the owner of the property convey marketable title without any reference to any trust clause? I mean, it doesn't show up in the record, and that's all any stranger to the transaction would be able to look at, in my opinion. Am I wrong about that, or help me here?
Well, again, Your Honor, I believe that based on our experience now, if they want title insurance, I can pretty much tell you that's going to be an issue. But the deed was, the grantee in the deed is the trustees of Harvest Church United Methodist. So somebody's going to have to determine what that means. And so if a lawyer is passing on a transaction from Harvest Church United Methodist, they're going to want some type of assurance what that really means, who is able to convey title in that case. And we would respectfully submit that the church is on record that it's subject to the trust clause. And so they know that permission from the United Methodist Church would be needed in that instance.
Mr. Northcutt, I expected you to respond to Justice Seller's question by pointing the court to 2503.1 as well. As I read that section of the Book of Discipline, it indicates that even if the language was absent in the deed, the property still held in trust for the benefit of the denomination.
So Your Honor, that provision would be in 2503.6. Okay, what paragraph 2501 provides is that the trust clause exists through the conveyance. Okay, and that all, in fact, the title of paragraph 2501 is all titles are in trust. And so that's the general provision for 2501. Then 2503.6 comes along later and says, notwithstanding the...
Sorry, I meant 06.
I thought you did, Your Honor. Notwithstanding paragraph 2501, if the language is not in that provision, then the trust clause still applies under 2503.6.
Mr. Northcutt, I know your time's running short in this round, but I want to tell you, I'm struggling here with what the ecclesiastical question is before the circuit court. You've asked us to apply the ecclesiastical abstention doctrine here, and as I look at the complaint filed by Harvest, they don't say anything about disaffiliation in the complaint. That's something that the conference, that your clients have interposed. And so I'm wondering, all Harvest seems to be seeking in its complaint is a declaration of whether there was a trust. So why is disaffiliation relevant or necessary to resolve that state law question?
Mr. Norcutt, your time has expired. You will be allowed to respond to this question and then to wrap up. Give us a wrap-up statement.
Justice, let me try to then phrase it as quickly as I can. So first of all, the Book of Discipline is an ecclesiastical document, and all these provisions are ecclesiastical. And so they're asking a circuit court to rule that an ecclesiastical provision, an ecclesiastical law, is unenforceable. That, to me, is ecclesiastical. I would point the court to the U.S. Supreme Court decisions in Watson v. Jones, Serbian Orthodox, Our Lady of Guadalupe, the Kedroff decision and the Kreshik decisions that speak to this issue about the purpose for the ecclesiastical doctrine and church abstention is to protect religious organizations from state interference into issues of governance, policy, and faith. And that's what this would do. The complaint does mention disaffiliation, and at that point in time, Your Honor, it had not been decided, but it did mention that disaffiliation was being considered. They later chose to disaffiliate. And so if, in fact, they want to disaffiliate, take their property free of the trust clause, then what they're going to have to seek is to have a court declare not only 2501 and 2503.6 are unenforceable, but also paragraph 2553. And Your Honor, in the Oklahoma Supreme Court decisions in Timmons 1 and 2, the Oklahoma Supreme Court said that is a bridge too far, that the Book of Discipline is an ecclesiastical document, and that paragraph 2553 specifically was an ecclesiastical provision that courts are not free to interpret or to not enforce. I hope that answered your question.
One other justice has another question. Ms. Northcutt.
I just want to understand what we mean by ecclesiastical, and you've tried to enlighten me. But it seems to me that you can put whatever you want to put and call it ecclesiastical, and so therefore it exempts the church out because it's considered ecclesiastical. It seems like property issues, no matter what we're talking about, we're going to put it in the Book of Discipline and say it's ecclesiastical. Is that a true statement? What the United Methodist Church does?
Your Honor, if I understand the question, let me approach it this way. So the term ecclesiastical means, according to the Merriam-Webster definition, anything related to a church. Okay, so it's broadly stated. The church autonomy doctrine, as enunciated by the U.S. Supreme Court, also known as the ecclesiastical abstention doctrine, specifically speaks to the church autonomy in the First Amendment applying to not just matters of faith, but of church governance and of church doctrine and all of these matters.
I guess you'd put property in there too.
And so property would be there too. And what the Oklahoma Supreme Court has held and what the U.S. Supreme Court has held is this: neutral principles which they rely upon can apply to narrow property issues, but neutral principles cannot apply when it comes to matters of ecclesiastical doctrine or polity. And the Timmons cases in Oklahoma went further and said that even if you have a property dispute, if that property dispute is inextricably intertwined with the larger denominational issue, then the courts have to stay away from it.
What is a narrow property issue that you just mentioned to me then?
What is a narrow property issue? Your Honor, I could foresee that maybe the Haney's Chapel case may have been a narrow property issue. But I don't think that there is a narrow property issue if it involves the interpretation of provisions of the Book of Discipline, especially if a court is being asked to declare as unenforceable a part of the Book of Discipline that has governed a denomination since 1797, that churches agree to follow when they join the denomination, and I think that's important here. Churches agree to abide by the Book of Discipline when they join the denomination. In fact, the U.S. Supreme Court in Watson v. Jones held that all who unite in a voluntary religious organization do so with an implied consent to follow its rules. Serbian Orthodox case said the same, and so the Supreme Court has been very clear on that point.
Mr. Northcourt, could you wait just a moment, please? For the sake of the audience, we allow equal time to both sides in the case. We have allotted 20 minutes, but if questions still are pending from the bench, I will allow those, and Madam Clerk, will you therefore enlarge the time of the respondents according to that? So we have another question.
One quick question. You've mentioned several times that in order to decide this case, we have to declare certain provisions of the Book of Discipline unenforceable. Why can't we just look at the face of the deed and the provisions of the deed as it was executed and, I guess, for lack of a better term, ignore the Book of Discipline? Just, this is what the deed says, and it doesn't implicate the Book of Discipline. Why can't we just treat this as strictly a property issue based on the face of what the deed says?
Because, Judge, twofold. The deed says that the property is granted to 3 individuals as trustee for the Harvest Church United Methodist. So that implicates the United Methodist Church. The certificate of incorporation and articles of incorporation do the same. So I think one has to go beyond the deeds to see what the other facts are to apply them for what is meant in the name of that grantee. They could have just said the Harvest Church, but they didn't. It said the Harvest Church United Methodist. And when you consider the totality of those documents and you add to the mix that they want to disaffiliate and take the church property, then I think the court has to look at the fact that the church property issue is inextricably intertwined with the ecclesiastical issue. And I would further suggest that to do otherwise disrupts the ability of a hierarchical organization like the United Methodist Church to govern itself.
Mr. Northcutt, if I may, Chief Justice.
Yes. Judge Edwards.
Refresh me, please. 2553 redresses what in the Book of Discipline? Is that the dissolution or disaffiliation? I'm sorry.
You're correct, Your
Okay,
Honor. That
right,
is
so
the disaffiliation provision.
If 2553 wasn't an issue, would it still be your argument that the court can't decide the trust provisions in the deed and who in fact does hold title to this property?
Based on the facts in this case, I would, Your Honor, and that is what AME Zion and we think Carnes v. Smith did, is they looked at the totality of the circumstances, and in both of those cases, they held there was no deed with a trust clause in it. Nevertheless, the Supreme Court, the Supreme Court of Georgia, held for the denomination because it was in the denominational document.
Yeah, that's I'm trying to. That I understand that. I'm saying if Section 2503.1 and 253.06 were all at issue here, so that disaffiliation in 2553, let's just take that out. If that was because it's plain to me in the Book of Discipline, the requirements, once you are a member of the United Methodist Church, how property has to be held. I mean, without deciding any religious question.
Right.
Plain language of this document makes it clear to me that title has to be held in trust for the benefit of the denomination.
Right.
If that was the only question that the court had to decide, would it still be your argument that the court doesn't have jurisdiction to do so?
Yes, Your Honor, it would be. Based on the facts in this particular case, it would be.
Ms. Northcutt, we have one more question.
Mr. Northcutt, I apologize. I think we're all trying to wrap our arms around it, but it seems like to me here you've got a deed, and in order for a deed to be valid, you have to file that with civil authorities. And so once you file with civil authorities, then that makes the civil authorities and not the ecclesiastical authorities basically the commander of what the deed says. And you also have articles of incorporation, which is the same scenario. You file those with the civil authority. You're constrained by what the law says to what articles of incorporation do or don't do. So we don't, in my opinion, get into the ecclesiastical issue. So if we've got a deed that says trustees, wouldn't we, rather than reference the book of discipline, reference the articles of incorporation to see who has the authority within that particular organization to appropriately convey property, or is that somehow superimposed on the actual denomination? So regardless of what the articles of incorporation say, we still have to reference the hierarchical authority to know exactly who has the authority to receive title and to convey title.
Your Honor, I think you have to do both. I think if you're dealing with, that's the very nature of a hierarchical and connectional relationship with the church. When the local church agrees to be a member of the hierarchical and connectional church, again, according to multiple Supreme Court decisions, they agree to be bound by the governance of that church. That brings into play, that's a consent to be bound by the ecclesiastical principles, the ecclesiastical laws of that denomination. And we do not believe that it would be appropriate for a church to be allowed to ignore what it agreed to when it joined a denomination and just run to a circuit court and say, well, I don't want to follow the church law, regardless of what's in the deeds, regardless of what's in the articles of incorporation, regardless of the fact that we applied for grants, received money for startup costs from the denomination. We don't want to pay any attention to that. We'll just let a court say, we don't have to follow ecclesiastical law. And to me, that violates the First Amendment and the church autonomy doctrine, because that's exactly what those doctrines are intended to protect against. It's intended to protect the integrity of the ecclesiastical organization, subject to the ecclesiastical laws, policies, and procedures that govern that organization.
So by filing, have you waived any right? By filing with civil authorities, have you waived any right? Or you're using the civil laws to organize your church and decide how the property's done. So I'm trying to understand how the First Amendment could apply, because you've already said we're going to file a deed under Alabama law, we're going to file articles of incorporation under Alabama law. Haven't you waived any argument about that by taking advantage of the civil authorities allowing deeds to convey property and articles of organization or incorporation to say how a church can be organized?
Your Honor, we don't believe so, because again, there's a certain amount of trust here. There's an assumption that when a deed is recorded, and it does have to be recorded. Articles of incorporation, the certificate of incorporation would have to be recorded. But that doesn't mean it's no longer subject to the trust clause. Again, the organization joins a hierarchical denomination and agrees to abide by the ecclesiastical laws and procedures of that organization, and can't then just go to a court of law to get around having to comply with those requirements. So it's still subject to the trust clause.
Ms. Northcutt, thank you for your time.
Thank you.
Now, Mr. French, your time will be enlarged with the overrun of his time, but we will keep your requested warning time the same. Okay.
Thank you. Mr. Chief Justice, and may it please the court, my name is Ryan French, here today on behalf of Harvest Church. And let me first acknowledge I'm here pro hoc vice and only with your permission. And I appreciate the privilege of arguing here today, as well as the privilege of representing my client, Harvest Church. This entire case, and what I want to get to is the notion that anything, and I'm quoting from opposing counsel here, anything and everything to do with the church is ecclesiastical. And therefore, essentially, if we put it in our book of discipline, it becomes ecclesiastical, it becomes off limits, and we have our own special rules that the courts are obligated to enforce and not to give any benefits or favors to local churches in that situation. We know that can't be true. We know that a church or any other religious organization can't pass a rule that says our members can assault each other and beat each other up. Well, why is that rule not enforceable? Because there are certain things that are separate. They're in separate categories. You can't just call it ecclesiastical and deem it off limits to courts and to the rest of the law by putting it in your book of discipline. And what matters is that doesn't just apply to assault and tort law, that applies to contract and property law. Let me first start by, at a high level, as best as I can do the job, summarizing what the law is on ecclesiastical jurisdiction, or ecclesiastical abstention. You have the Watson v. Jones case, that was in 1871. Then you had the Kedrov case, a related Russian Orthodox case in the 50s. You had the Jones v. Wolf case in 1979. And you had the Milivojevich or the Serbian Orthodox case in 1976. If I could amalgamate the holdings of those cases for you, they are: courts have no jurisdiction to decide doctrinal or ecclesiastical disputes. And in some cases, it's not wrong necessarily to just defer because we want to be so careful, we may have to defer to the higher church authority if we have any doubt about something. That's the Watson case. That case is 150 years old, and it's not the law anymore. It's not the law of the U.S. Supreme Court. It's not the law of Alabama. The cases since then have made clear that, yes, there is one category of ecclesiastical disputes, doctrinal disputes, internal affairs. There is an entirely separate category that is mutually exclusive for property. We know this because that's exactly what the Jones v. Wolf case said. It said, yes, we have to stay away from doctrinal things. We have to stay away from ecclesiastical things. We do not have to stay away from property things. And that is true even when it's a property dispute between a church and a denomination. Of course, there are some cases where there is some potential overlap. So what happens when we have a case where there is a property issue that we can identify and we can resolve, but there's also an ecclesiastical issue? Well, you combine those concepts. The end result is that you stay away from any ecclesiastical issue that you do not have to answer. You only focus on the property issue. You ignore any religious notions, or as the Supreme Court said in Jones v. Wolf, we don't rely on any religious precepts when we look at the documents, even if it is a religious document. Instead, we're going to look at state law in those cases.
Mr. French, let me ask you to pause just a moment. It seems you're setting out three categories: ecclesiastical, non-ecclesiastical, and mixed. And which of these three categories are we in this case?
In this case, Your Honor, we are clearly and firmly in the property category. What the Milivojevich case says is sometimes you have a property issue that you can't get to because the parties have for some reason said that have agreed that you can't get to the issue until you first resolve a religious issue. So for instance, the Milivojevich case, that was a case where there wasn't property at issue. Everyone agreed that the property was in control of a corporation, and everyone agreed that the person who rightfully controlled that corporation was the bishop. The dispute was over, well, who's the bishop? And in that case, it was the Russian Orthodox Church, so it wasn't the Pope, but the equivalent of the Pope said, well, this is the bishop. I'm the Pope. I get to make that decision. The court said, yes, we have to accept the Pope's determination of who the bishop is. And you can't, just because that might affect some property rights down the line, that doesn't mean that this is a property case.
But Mr. French, when in a deed the term Methodist is used, that's obviously, for want of a better word, a franchise. It's a brand. People know what Methodist means. So by using the term Methodist in your deed, doesn't that imply that you plan to be a part of that organization, that you would be subject to the rules that govern what the term Methodist means?
I don't think so, Your Honor. We know that because we've got several decisions from this court where you had similar identifiers in the property deeds or in the corporate name or in both. In none of those cases was it dispositive or did the court find it decisive that you had a denominational identifier. It's just a fact that lots of churches, even though they may shift in and out of denominations, they use a denominational identifier in their name. Methodist actually is not, there's a bunch of brands of Methodism. There's a Global Methodist Church, there's the United Methodist Church. There's other Methodist denominations throughout the country.
So then do we look to what the word Methodist means at the time the deed's recorded to know exactly what they intended that to mean and what they agreed to be governed by?
My ultimate point, Your Honor, would be that we apply neutral principles. Is this, and I'm skipping ahead here, but is Alabama a neutral principle state? Yes, that's what the court said in Tankersley. We've said it several times since. That means we apply the same rules to churches and denominations as it respects property rights that we apply to everyone else. So then we would ask, if somebody, if you or me or a business were to include the name Methodist in its deed, is that enough to give the Methodist Church a enforceable proprietary interest in that property to the end of time? The question in that case then, under existing Alabama law, as it applies to everyone else, and therefore as required of the neutral principles, is there evidence of an intent to create a trust? Is it in writing? Does it have a legal description? And if we conclude from all of those things that yes, Harvest Church clearly intended here to create a trust by using that one word, and there's evidence that supports that, I would have to concede that that means that there would be a trust in this case. The problem is, and if we're getting to the merits, there is no evidence like that. In fact, the affidavits that were originally filed with our complaint show that no, this was very specifically not intended to create a trust. This was just to show that we were connected to the United Methodist Church for a time. It wasn't intended to create any property rights. We specifically told the United Methodist Church on numerous occasions from 2007 or 2005 to the present that our deeds do not have a trust clause and are not subject to your trust. We have contemporaneous affidavits from those who were involved at the initial acquisition of property and the initial formation of the corporation that say, no, we knew that some churches create their property in trust. We absolutely didn't want to do that. In fact, Harvest Articles of Incorporation specifically say we are not subject to any outside authority or influence. Every decision concerning us and our property shall be final and binding as made by our members or our board.
Now, didn't the members of the Harvest Church accept money from the United Methodist Church, the global, that's the wrong word, the United Methodist Church?
They did, Your Honor. There's evidence in the record that a $25,000 grant was at some point received, and I think that's the entirety of the evidence. It was a no strings attached grant, just as if it was you or me. If somebody gives you $25,000 and doesn't say you have to agree to anything or do anything in return, then it's a donation. You don't have to do anything in return. Had it been a strings attached grant, or it had a right of reverter, or it had contingencies attached to it, which it didn't, then we would look at what those contingencies are, and maybe we would have to return that $25,000.
So is it your claim you were never a member of the United Methodist Church?
Oh, no, Your Honor. We were absolutely a member of the United Methodist Church for 25
all right.
years.
So I have a question. So you've admitted that you were a member of the United Methodist Church, and in oral argument before the trial court, your counsel stated that the church isn't necessarily bound by the Book of Discipline, or we've never bound ourselves to any of the discipline provisions. So in light of these statements, how could a decision be made in favor of Harvest regarding church property without implicitly establishing what it means to be a local United Methodist Church, or that a local church can be a local United Methodist Church but not be subject to the Book of Discipline or certain other parts?
The problem, Your Honor, and that presents the ultimate question, is the law the same for churches and denominations, or is it the same, or is it different for those? No other group of people could come to court today and have any reasonable debate about, well, my articles of incorporation or my governing document that I wrote says I get their property, therefore I get this person's property. We would laugh that person out of court. But we sort of make this exception for when a church comes in, and because it joined this club, and the club in another document that the member never signed on to, never explicitly agreed to, never endorsed or accepted in any binding document or any document at all, how can that member of the club be bound by the club's rule book that says I get all your property? That wouldn't happen in any other situation. And all neutral principle says is we ask the same questions in those situations.
Isn't it a fact question, though, whether your church agreed to the Book of Discipline?
Yes, Your Honor, it is. And that's really not the issue before the court today.
Let's take that apart real slowly, okay? Let's assume that the trier of fact determined that you were bound by the Book of Discipline. Okay? Is that an ecclesiastical issue at that point? Determining whether there's a trust or not, and whether you violated those trust provisions, is that ecclesiastical issue at that point if, as a factual matter, is determined you're bound by the Book of Discipline?
No, Your Honor, and I'll skip ahead to, if I could. This goes a little bit back to what I was talking about, that the case law in the Supreme Court very specifically says there's property issues, there's church things. You don't have to stay away from you do have to stay away from doctrinal ecclesiastical things. You don't have to stay away from property. What happens when the church's spiritual book or its ecclesiastical book purports to govern property? This court answered that question in the Taylor decision in 2017 and said, you don't get to immunize or exempt property rules just by putting it into a discipline. In fact, there is no jurisdiction, and in that case, that was a case about the removal of a pastor. We're not going to look at the Methodist denomination's provisions on removing a pastor and determine whether or not that's enforceable. That's off limits. However, were this about property or some secular issue that courts resolve all the times, we absolutely can go and look in the discipline. In fact, that's what we do under Jones v. Wolf. We look at what the parties say are the relevant governing documents, and then we ask, under Alabama law, do these documents add up to a binding transfer of property? And the entire factual problem in this case is a binding transfer of property for anyone else in the state requires, if not a deed, then some other written instrument with a legal description showing an intent to transfer property in very explicit terms.
So just so I'm clear, your argument is even if we determined there was no issue of fact and that you were bound by the Book of Discipline, you would say even then the Book of Discipline doesn't constitute an ecclesiastical issue as to the property, because what we're doing there is we're applying Alabama trust law and Alabama contract law to determine if the words in the Book of Discipline are sufficient to either create a contract or create a trust under Alabama law.
Exactly. And what I would present will be the dispositive question in this case is, do we have written consent by my client, Harvest Church, to transfer its property? Did it sign a resolution accepting the Book of Discipline and every provision thereof, including...
Is that the only way to sign some document? Or, I mean, it seems to me a court could ask you numerous questions, or evidence could indicate in numerous ways that you were, in fact, a member of the United Methodist Church subject to the Book of Discipline without actually having to have a signed document to indicate that.
That's a different question, Your Honor. That the question is not, are you a member of the denomination? The question is did you comply with Alabama law, which says you need a writing to transfer property, and that writing needs to have a legal description, and it needs to be clearly intended by the transferor or the grantor to transfer property. To instead just ask is if the church was a member of a denomination, you skip that whole process, and then you create a different type of property trust law for churches, which is not neutral principles. And this goes to the extent that their substance has sort of been imported into this case. What the conference has done is they have said, as part of their jurisdictional argument, they have a couple jurisdictional arguments, but they also say that this is sort of a special case. And while this court has applied neutral principles, the same rules, to other churches, this is different because there's such a connection here, and we have so much of a hierarchy that you need to treat this case different. That has shifted this into a new category, a church law category. And in that category, what's relevant is the denomination hierarchical? Are there sufficient acts of allegiance and membership vows? And I'm not making these factors up. These are, unfortunately, from the Zion Hill decision in 1988, which purports to be a neutral principles decision. And I would suggest to the court it is not. Neutral principles says we look at state property and trust law.
Okay, so applying neutral principles here with the deed, who right now has the authority to convey title to this property?
Only Harvest Church, without question. They're the title holder.
But the deed doesn't say that. It says trustees.
Oh, well, they're trustees for the corporate entity, which is Harvest United Methodist Church.
But it wasn't a corporate entity.
Oh, well, I'm sorry. It's been incorporated since then, and under Alabama law, I believe is recognized, I think, in the Tankersley decision, the incorporation of an unincorporated church automatically vests the title from the trustees into the corporate entity of the church. And I can cite the court to that authority in a supplemental brief.
Okay, so following this, then, the corporate entity, they have the ability to convey title to whoever they want to.
Yes, Your Honor.
So then why would you go into court and ask for a declaratory judgment?
Because we know that they have the opposite view. We know that if we didn't come to court and ask for a deck action, they were going to come to court first. Or what we were really scared of, and I've been told that my fears were unfounded, is that they would exercise their ecclesiastical authority to take over our church and maybe prevent the church from hiring me. Or when I do show up in court, take the position that I don't actually represent the church. It's not the true entity anymore. And so, having done a couple of these cases, the only safe way to show up in court on behalf of a church is to act first oftentimes and to obtain that declaration of property rights first, where there's no question that I'm representing the church. The church is in charge here. The board wants this declaration.
Justice Brian?
Yeah, I want to ask you, I'm following up on Judge Edwards and Justice Cook's questions. Is there any provision in the discipline that is relevant in this case?
Your Honor, I would submit to you the discipline is only relevant if there's some evidence that we explicitly consented to it in a writing. Because what we're really arguing about here is real estate. We're arguing about $10 million worth of property in Dothan. And in order to transfer that, you need a writing that says, I want to transfer it, and this is what I'm transferring. If the discipline said that, then or we agreed to the trust clause in some other writing that sort of plugged those requirements together, then the discipline would become relevant.
So your contention is it would have to be somewhere in writing that you agreed to be bound by the Book of Discipline. There would have to be some agreement that somebody from the church signed.
With proper authority, yes, Your Honor. And that's just
Is that typical? Is that typical for the United Methodist Church that you have to, following up on Judge Edwards, is that typical that you have to have a signed writing for the Book of Discipline to apply?
Of course, they don't have the same view of the law, Your Honor. Their view of the law is that if we adopt a rule, it's binding on anyone who comes near us and hangs out with us.
I think he's asking what is normal.
Oh, that's what I'm...
Other churches, UMC, sign something saying, we agree.
Excuse me, Your Honor. Yes, there are plenty of cases, because frankly, I turn those cases down. Those are cases where the deed, the explicit trust language is in the deed. Or if it's not in the deed, the church has adopted articles of incorporation that say, we hereby adopt the entire Book of Discipline as amended, and that this provision shall not be amended or taken out of these articles of incorporation.
I'm really struggling with how you can admit to be a member of the United Methodist Church, but then your argument is that you're not bound by their Book of Discipline. Help me with that.
The question, Your Honor, is it's neutral principles. I was a Boy Scout. When I was a Boy Scout, by joining the Boy Scouts, I didn't become legally bound to the Boy Scout handbook or manual. Had I agreed in some writing where I said, okay, I've gone through this, oh, I see here on page 35, you claim my property. Okay, I agree to that. Then I would become bound to that page of the Boy Scout manual because I've now agreed to it. But until then, it's just a unilateral document that they've passed themselves that they say is binding on everyone who comes near them. So that's not enough under the law for regular entities, so it can't be enough for churches to lose their property so easily.
Council's not to oversimplify it, but I'm trying to wrap my mind around it too. What you're basically saying is that normally a Methodist church who wishes to be bound by the Methodist Church Book of Discipline would either put the trust language in the deed or in some other way in writing adopt that language. And so what we have here is basically not, again, this is not a pejorative term, but basically a rogue church that decided not to do that. In this case, intentionally or otherwise, they did not put it in there. And so they're a little different from, and again, I don't mean rogue in a bad term, they're just different than the normal. And am I oversimplifying it, or is that?
I would state it like this. There are some churches who have created trust instruments or signed contracts with the United Methodist Church, and those are enforceable when they comply with state law. There are some churches, like Harvest, that have not signed contracts with the United Methodist Church, and therefore there is no contract.
And either way, it's still a matter of state law as to whether what the deed says is what we should look to.
Correct.
Okay.
And one point I want to make clear, because I know this bothers you, Judge Edwards, that they could join Justice Edwards, that they could join a denomination that has rules but not necessarily be bound by those. Well, that entire premise is based on this concept of hierarchical. So even under the law they cite, this Watson v. Jones case, to get to this conclusion, and this is an old case that's been superseded by neutral principles, but to get there, you ask, is the church hierarchical? So then you look and you start diving into this inquiry, and you go into the church and say, well, how much authority do they claim to have? What is the basis of the authority? Is it truly hierarchical, or is it more Presbyterian and democratic in nature? Or even if it is, how much, you heard the term connectionalism. You heard there's a connection between the two. What does that mean legally? How do we dissect that? So then we have to go into what is the degree of allegiance that this church had with the denomination. And you start looking at were there membership vows? Did the pastor take a vow? Did the pastor show up at meetings and speak and participate?
And vote on changes to the Book of Discipline.
In group activities, and you can see how, and this is to be fair, what happened in the Zion Hill case may be out of necessity because there was no deed, but you can see the mess that could create, and the evidence that literally decided that case was membership vows, and to what degree the church was known in the community as being associated with a particular denomination. And did they use hymnals and literature? And it's a very mealy inquiry, and that's exactly why in Jones v. Wolf they said, and because they addressed the dissent in that case, because the dissent said that's how we should decide these cases. We ask if it's hierarchical, and if it is, then they're bound by the rules because they're part of the hierarchy.
Mr. French, I want to ask you a question. I'd like you to ask one question to Mr. Northcutt before he sat down. He indicated, if I understand his argument correctly, that the ecclesiastical question the circuit court has to decide here, which gives rise to the ecclesiastical abstention doctrine, is disaffiliation.
Yes, Your Honor.
That's really what's going on here, and the property is part and parcel of that. Therefore, we're in ecclesiastical territory, and the court should be out of it. I just want to give you an opportunity to respond to that.
Yes, Your Honor. So in some ways, that's one of their top 2 or 3 arguments here, that this is really about disaffiliation. It's not, I think, as you pointed out in questioning to Mr. Northcutt, that's not what our lawsuit asked for. We very specifically pray only for a recognition that Harvest Church alone is the absolute, full, exclusive, fee simple owner of all real and personal property that is owned by the church. So that means, according to the way we've pled it, and we're the master of our pleadings, we cited everything that's relevant to be entitled to that relief. This is a property question. Therefore, it's mutually exclusive then. It's not in the ecclesiastical category. Sometimes these comparisons sound a little crazy, but they're not if we're actually looking at churches the same way. If I come into court with my sister and we're fighting about property, the court is going to say, okay, well, here's why do you claim the property? Here's the winner. The last thing the court is going to ask me is, well, why don't y'all get along better? Why aren't y'all getting along? Let's talk about that. That's just not relevant. It's not admissible. And it's the same is true when 2 churches or 2 religious organizations come into court. You don't ask, why do you want your own property, or what is your future relationship going to be? You just tell them who owns the property. And don't just take my word for it. And I do have to apologize. As much as I pride myself on thorough research, I failed to cite this court previously to Murphy v. Green, which is a decision from this court in 2000. That's at 794 Southern 2nd, 325. Why it's so relevant is because that was a case over two factions of a Presbyterian church, a hierarchical Presbyterian church, fighting over property. The trial court had considered as part of the issues whether or not the pastor or one of the factions had loyally followed Presbyterian tenets. This court said, whoa, you don't bring that issue into here. We're here for property. And of course, that's me paraphrasing. But what is not paraphrasing is this language, quote, although it is arguable that spiritual issues prompted the division in the York congregation, this case involves the civil conflicts of trusteeship and property ownership. The resolution of these issues requires a court merely to review church records and incorporation documents without delving into spiritual matters. And they said something further, though. In response to the appellate courts or the trial courts, even consideration of an off-limits issue and how that might arguably relate to property, this court said, we've carefully considered this argument. We do not understand how it is relevant to this appeal. Moreover, even if we concluded that the appellants had violated the Presbyterian tenets, it is not apparent in a case involving a property dispute how any violation or lack of violation of these tenets could matter. You don't get a closer set of facts than this. There you had a party trying to talk about an off-limits issue, saying that's what the property issue is really about. The court said, I can decide a property issue just fine without asking you what other problems you have. You have this idea in their brief that, well, we want to raise some doctrinal issues. We have some ecclesiastical defenses. I'm not sure what those might be. And that it's not fair to allow the property issues to be litigated, but our ecclesiastical defenses to not be litigated. This court has actually considered a similar situation. In the Yates case in 2002, it cited to a much earlier case from 1881, the Wilmer case. And in that case, the dispute was ostensibly over custody, who should rightfully get custody of a child whose parents had died. Well, one of the parties came into court talking about trustee law and custodial law under Alabama law. The other party came into court talking about Catholic doctrine and why that's what the father was and why that's what should govern the future raising of the child. This court said, nope, we're only looking, and again, that's me paraphrasing, we're only going to look at the neutral law that governs custodial disputes. And what it did say is, it's our duty to, quote, deal with the case upon its dry legal bearings, as if it presented no question of religious differences. A good example of this, and this is another case I didn't cite in my brief because I only uncovered it this weekend, the St. Union Baptist case from 2016 from this court, 211 Southern 3rd 804. And it was a very similar situation. You had one party, the pastor, who was suing, claiming that the board or some other governing body of this church had taken money or misappropriated funds, very much a civil financial claim. The other party countersued and said, well, we don't think you're the real pastor, and you're not a legitimate pastor because you don't meet certain requirements. This court said, that claim is dismissed. We don't have any jurisdiction to hear this claim about whether or not the pastor was appropriately removed or not, because that's beyond our jurisdiction. Pastor, however, gets to continue to assert his claims, which relate to misappropriation of funds and other commonly recognized civil remedies.
So I asked your opposing counsel, are we able, or is a court not able to just look at the face of the deed? And you know, I think there's been a lot of suggestion that in order to interpret the deed and to determine who owns the property, we would have to find and validate certain provisions of the Book of Discipline. But really, do we have to go there? Is it not just looking at the deed and then, I mean, can we not, in a sense, ignore what it says? What does the deed say?
Well, and sorry to do this to you, but in addition to his question, if in fact the circuit court can't just look at the deed and has to determine whether or not Harvest United Methodist Church is in fact, has to answer the question, are you or aren't you subject to the Book of Discipline, is that not a religious question?
No, Your Honor, not if the only question is the property subject to a trust. And
that's not my question. My question is, if the circuit court had to decide, in order to decide that it's not just the deed they have to look at, that they have to look at whether or not you are a member of the United Methodist Church subject to the entire Book of Discipline. If that is a question that the circuit court has to decide in order to decide who owns this property, is that a religious question? Or is that just we can look through a secular lens and determine that?
it's not a religious question. It's exactly as you say. You look through a secular lens. You look for any documents that bind or any other statements that legally bind my clients at the annual conference. And that's not just my opinion. This court got pretty close to addressing this issue in Taylor, where it said, we can dive all into your governing rules and provisions as it relates to proprietary and civil matters. What we're not going to do, and what is a bridge too far, is to dive into your governing rules and provisions as it relates to things that we can never touch to begin with, such as, and if you look at this court's ecclesiastical abstention jurisprudence, there's not a single case, that, at least that I could find, in 150 years or longer, as far back as Alabama law goes, in which it disclaimed jurisdiction on a case that in any way had something to do with property. You've got a line of cases, and this is talked about well in Chief Justice Parker's concurrence in the Tatum decision. It's also pretty well set forth in that Taylor decision, which I just cited from 2017. It goes through the types of cases that have been held to be off limits. They fall into just a couple of categories that have nothing to do with property. It's the appropriateness of removing or not removing a member of the church, the appropriateness of removing or not removing a leader. It's tort claims based on, one member suing another saying you abused the disciplinary process and got me into trouble with the presbytery or with.
So is it your contention that that's an exhaustive list? Like there can't be any other?
It's exhausted. I would say it's illustrative under the case law.
It's all the precedents have, right?
It's all the precedent, but it's not in a vacuum because at the same time, you have at least 8 cases in which the Court of Civil Appeals or the Supreme Court has considered disputes just like this one based on trust clauses, just like this one, based on disciplines, just like this one, based on similar unilateral withdrawals, based on accusations that there's a connection to the denomination and that matters and we should dive into that. We should see what kind of vows were taken and if there's a sufficient connection. That's the ex parte cases from this court in 2003. In none of those cases was jurisdiction declined.
So do we have to declare provisions of the Book of Discipline irrelevant and unenforceable in order to decide this case, or can we look at the deed?
Well, it depends. I suppose, Your Honor, it depends if they ask you to.
Yeah.
If they say the basis of our claim is this Book of Discipline that we have no evidence they ever agreed to or signed or wanted anything to do with, then you'll have to say that's not a basis in this case for this church to bind them to those provisions.
Mr. French, in this case, you filed a deck action, and you've basically said, court, declare to us basically who owns the property. Now, in most situations, if they said, Mr. French, and you're the grantor in the deed, it's pretty clear who you are. There's no further inquiry. In this case, you do have a further inquiry because you've got individuals, they're designated as trustees, and you've got them designated for a church, and not just any church, but a church that is denominationally recognized. So it seems like we can look at the face of the deed, but the face of the deed calls us to ask further questions. Who are these people? Are they truly trustees? How are they affiliated with this church? And don't those inquiries, even though we look at the face of the deed, require us to look into who has the authority to basically own the property? And doesn't that loop you back in to the Book of Discipline?
Mr. French, your time has expired, but you may respond to this.
Yes, Your Honor. It doesn't loop you. Well, let me first start by saying, yes, just as in any case, although the deed is usually dispositive, you don't ignore other relevant evidence that could be legally relevant, such as you don't necessarily need a deed recorded. You need it to be recorded to affect third parties, but to have it be binding between us, you still need a deed. It just doesn't have to be recorded, or you need some written contract or instrument. So you do ask those questions. Are there other contracts or instruments, though not recorded like a deed, also satisfy the statute of frauds and the legal requirements? You would look into those issues. And no, it would not be a problem to ask to, and under state trust law, you always ask about intent. That's the penultimate, or that's the ultimate question, is intent. So you do look at evidence of intent because that's one of the things they have to prove to establish a trust. You don't get into trouble by doing that, even if you look at the discipline. And we know that because the Jones v. Wolf decision, which is what cemented neutral principles, said, yes, you may have to look at religious documents, but you do so through a secular lens. You don't rely on religious precepts, and you treat the parties, you treat it as if it's any other suggested contract between the parties. You just interpret it, and if it's binding and there's consent and the form requirements are met, you enforce it.
Thank you, Mr. French.
Could I just finish one other point, Your Honor? And it's no problem if I can't.
You may give us a summary conclusion.
My only suggestion when I was attacking the Zion Hill case is that this inquiry into hierarchy, that's exactly what the Jones case said you should stay away from, because that is what they call it, a searching and therefore impermissible inquiry into church polity. It's the very nature of the analysis that they're proposing that presents the biggest jurisdictional risk here. It's not the appropriate analysis under this court's precedent or under Supreme Court precedent. Thank you, Your Honor.
Thank you, Mr. French. Mr. Livingston, while you're approaching the microphone, let me say this to the public here. I said earlier that we give equal time to both sides, to the petitioner and to the respondent. But in this situation, the petitioner has decided to divide that time that they've been allotted to allow a closing. And that's what Mr. Livingston is going to do now.
May it please the court. My name's Alan Livingston. I practiced law in Dothan for more than 50 years. For 27 of those years, I served as conference chancellor for the Alabama West Florida Conference of the United Methodist Church, including the time that Harvest United Methodist Church was formed. It grieves me deeply to stand here in an adversarial relation with Harvest. It really grieves my heart. But I want you to know that the conference never once threatened Harvest in any way. Harvest decided to bring this litigation. There are two facts that are dispositive, in my opinion, for this case, for the court to decide this case. First, it is clear that Harvest is a United Methodist Church. There's no halfway United Methodist. You're either in or you're not. Harvest joined the United Methodist Church, and that's admitted in the pleadings, in briefs, in open court below, and in open court here just this morning.
And you would say they're still a member?
They have not withdrawn. But in briefs, Mr. French says, until recently, Harvest was a member church. Regardless, we say they've never withdrawn. There is a provision for them to withdraw, but they decided not to do that.
Mr. Livingston, I almost asked this question to Mr. Northcutt, that isn't the church the people of the church?
Certainly.
Well, if the people of the church decide that they're no longer a part of it, wouldn't that be a factor that we consider?
If someone wanted to leave the church, they certainly may. We don't, if an individual decides to leave the church, they can leave. They can join a Baptist church, they can join a Presbyterian church, they can do that. There's no question that the people can do that. The question is, what is the relationship between United Methodist churches? There is no question in this case that the United Methodist Church is a connectional hierarchical church, and the corresponding trust provisions of the Book of Discipline are religious doctrine and practices of the United Methodist Church and have been so for more than 250 years. That's part of the doctrine and practice of the United Methodist Church. Therefore, the issue before this court is whether the trial court exceeded its jurisdiction in purporting to adjudicate matters of doctrine and practice. Clearly, the trial court lacks jurisdiction to do that. Despite everything that Mr. French said, this case is really about only one thing. Harvest is trying to create a separate pathway to disaffiliate. That's what they really want to do. The conference...
It wouldn't be for everybody, though, right?
No,
they have some specific facts here.
Yeah, and they want to say, we're different than everybody else because we never really accepted the discipline because we didn't really sign anything. Well, no church ever signs a document like that.
Mr. Livingston, I believe in your Church of Discipline, as I understand it, is when a deed conveys property to a congregation or a church, there's supposed to be language that's different than this deed that says how the property is held in trust. Right. And isn't the fact that this deed doesn't have the language as prescribed by the Book of Discipline somewhat fatal to this argument that it's about disaffiliation and not about a real property issue?
No, Your Honor, it is not, because the Book of Discipline also says that if you fail to put it in the deed, that it is not dispositive. Section 2503 says that if it's not in the deed, it is still held in trust. All property, not just the real estate, all property is held in trust for the denomination. That is the connectional structure of the United Methodist Church, and central to that is the trust provisions for all property. So it covers not just what's in the deed, but all property.
Well, does it matter that the articles of incorporation, which now govern this particular church, also don't have that language? Again, from a pure secular standpoint, we have franchise. You go and you have a McDonald's franchise, and they say you got to do these things to be McDonald's, and if you own property, it's got to be done this way. And if you fail to do that, there may be some action that's taken to change the deed or change the articles. But if you fail to have that language in either the deed or the articles, from just a pure secular real property standpoint, looking at the deed, how can they not convey property on their own initiative without the consent of the hierarchy in the church?
Because the discipline sets out the procedure for conveying property, and that requires the consent of the conference.
But if that's not contained in the deed, how would somebody know that they're getting title? They've got to actually. There's nothing in the deed that says it reverts this way or that. So I'm just trying to understand how you could fold that in, and if it wasn't in the deed initially, shouldn't that have been when somebody filed suit and said this deed isn't valid under our rules because you don't have this language in there? Otherwise, we have the situation we have now where you got to have a deck action to figure out, well, who owns the property?
And even if your answer to that is that .06 exists, you've known for a very long time that this deed did not read the way that the Book of Discipline required it to read. Have you waived now any argument that you have because you've allowed the deed to exist the way that it has existed for as long as it has?
Well, let me respond to that, Judge. At times they reported that the trust clause was not in there. At times they didn't answer the question at all, and at other times they reported that it was there. So.
Well, if it was recorded, you certainly could have gone and looked if there was a question.
Right. We certainly could have, but the conference wouldn't go look at every recorded deed for every church.
Isn't this really just a breach of contract claim, though? I mean, if they didn't put it in the deed and they're subject to the Book of Discipline, can't you sue Harvest and say, hey, you breached the contract, the Book of Discipline's a contract, you agreed to this contract, whether you signed it or not, you knew what was in it, and you didn't follow it, now pay up for the $10 million that this property's worth?
I suppose that is something that could be done. We've never considered doing that. Like I said, the conference has never considered an action against Harvest.
Is a Book of Discipline a contract?
The Book of Discipline is the church law. Once they become a United Methodist Church, they're subject to the church law, just like every other church.
Okay, so Mr. Livingston, I'll ask you the same question I asked Mr. French. If, in fact, the circuit court would have to determine whether or not Harvest United Methodist Church was subject to the Book of Discipline because they did, in fact, fully join the United Methodist Church, is that a religious question?
Yes, absolutely. Their obligations to the general church, as set out in the Book of Discipline, are religious and doctrinal questions of church doctrine and practice.
So then it seems to me then that if you actually had, that you couldn't then go to court for breach of contract to enforce anything, because that would also be a religious question.
Like I said, we've never considered something like that. So,
Counsel, I got a
Yes,
question for you. So let's just hypothetically say we agree and we dismiss this case, no jurisdiction. Okay, but the deed, the fact remains that the deed is as it is, and Harvest Church claims to own it. The Methodist Conference claims to own it. How are you going to enforce your claim without going to court? I mean...
Well, sure. The Methodist Church has its own judicial department, and it will. This question would ultimately wind up in the ecclesiastical courts of the United Methodist Church, and would ultimately wind up there, and that decision would be binding on both parties. And if they,
But what if they don't? What if Harvest says we're not Methodist, we don't recognize that? how are you going to get your property? You're not going to storm the walls, I assume, but are you not going to end up in court at some point?
The determination of who owns the property and is the trust enforceable would be determined by the ecclesiastical courts, and once that decision is made, would be binding on the civil courts to enforce.
Mr. Livingston, your time has expired, but Justice Bryan has a question pending.
Just quickly, there was a lot of discussion by Mr. French about Jones v. Wolf, about
Yes.
staying away from doctrine, but you don't have to stay away from property issue, and I'd love to hear the response to that.
Yes, thank you, Your Honor, I appreciate that. Jones v. Wolf, if you carefully read the case, it's a 5-4 decision. Justice Blackmun wrote for the majority, and that's the seminal case for neutral principles. He noted carefully that the church in Jones v. Wolf was a Presbyterian church, and he stated specifically that there was no trust clause in the Presbyterian Book of Order. And he carefully noted and stated to compare that with the Methodist Book of Discipline. And he stated that the Methodist Book of Discipline, and he quotes the 2 paragraphs we've discussed at length here today, he quotes those in the footnotes. And then he says, this court is making the decision on Presbyterian law, but the court in Carnes v. Smith ruled for the denomination in the same exact way that we're here about today. The clear implication is that had Jones v. Wolf been a Methodist church, the outcome would have been different. So you have to carefully read all of Jones v. Wolf, and you'll see that it would have been different had it been Methodist. Yes, sir.
Thank you, Mr. Livingston. And our thanks to the counsel from both sides. You can see it's been a very engaging discussion with the bench here. Thank you for helping us by responding to our questions. And we will now take this case under consideration. And with that, we now stand adjourned.
All rise. The court is adjourned.